Today I present to you the Cruz v State of Victoria 2019 case by Olivia Kane, Matthew Carey, Tegan Fraley and Lucy Richards Fleming. The case of Cruz v State of Victoria 2019 involves a legal dispute that was heard in the Supreme Court of Victoria. Ethan Cruz was the plaintiff and he was the target of a police raid on 18th of April 2015, which formed part of a counter-terrorism operation called Operation Rising. Cruz was arrested during the raid without a warrant on the suspicion of involvement in a terrorism plot, however was released the following day without charges. Here is a timeline of important events. During the raid, Cruz was the subject of excessive and unnecessary force used by Victoria Police, which resulted in both physical and psychological injuries. The force used involved Cruz being verbally abused, struck in the head, pushed into a fridge, beaten whilst detained on the floor, all which left him with bruising, concussion, abrasions, as well as major depression and post-traumatic stress disorder. Cruz filed a lawsuit against the State of Victoria with allegations of excessive and unlawful force resulting in physical injuries and psychological trauma. The Supreme Court of Victoria was tasked with determining whether the force used by the Victoria Police was justified, reasonable and necessary. The case made it to the Supreme Court in July of 2019 and returned a judgment on August 27, 2019, finding that excessive, unjustified force was used during the circumstances. Cruz was awarded damages, some of which included aggravated and exemplary damages. The case was not an appeal, and to date, the case is final. The victim is Mr. Ethan Cruz, a person of interest in Operation Rising, who was under investigation into a planned terrorism attack. Mr. Cruz alleges that during a raid on his home, police officers employed excessive force, resulting in significant injuries. Mr. Cruz sought damages from the State of Victoria for the injuries sustained during the raid. He experienced severe physical trauma at the time and now suffers from post-traumatic stress disorder and depression. Mr. Cruz already belongs to a marginalised group identifying as Aboriginal, which placed him in an increased risk of systemic disadvantage. The additional hardships he encountered due to his interactions with Victoria Police further compounded his marginalisation. The State of Victoria was represented by Victoria Police as the defendant in this case. Instead of naming the individual officers involved, they are identified only by numbers. For example, Operator 205. Justice Richards was the judge that heard the case in the Supreme Court of Victoria. The State of Victoria contended that the level of force applied was appropriate and justified given the circumstances of the operation. Justice Richards did not view the circumstances of the operation as a mitigating factor for the severity with which the victim was treated. The case of Cruz v State of Victoria 2019 was a common law claim with the following tort of law under question: battery and assault, forcible entry by police to execute search warrants, plaintiff arrested without warrant on suspicion of terrorism offence, force used by police against plaintiff, whether arrest lawful, whether force used necessary and reasonable, force not justified. It was a case in which the State of Victoria were found to have used unjustified force and battery, and subsequently Mr. Cruz was awarded $400,000 in compensation. Judge Richards condemned the actions of the officers, particularly the actions of Operator 27, and found that within the context of the assault and battery inflicted on Mr. Cruz, the conclusion was inescapable. Judge Richards went on to say that the injuries inflicted on Mr. Cruz were indisputable. One or more police officers, armed and armoured, their face masked, struck Mr. Cruz repeatedly to his head, neck, upper body while he was laying handcuffed and defenceless on his parents' kitchen floor. As he lay there, bleeding from the head, one of them threatened him with more of the same. Mr. Cruz feared that he might die then and there. In further sentencing remarks, Judge Richards described the response from Victoria Police Professional Standards Command as victim blaming and further condemned them for not acknowledging or expressing any form of regret for the conduct of the police officers involved. Any allegation of police brutality is a serious offence and concern for the general public. Judge Richards noted that he doesn't make the findings lightly and that his findings may have adverse consequences for the officers involved, particularly Operator 27. The findings are concerning, particularly considering the exemption of punishment towards officers involved gives the impression of culture of impunity towards misconduct allegations. Primarily, the focus of the sentence was to determine if the actions of the police officers involved in the raid were justified and lawful. Upon determining that the actions carried out by the police officers were indeed unjustified, it was then the focus of the Judge Richards to determine if there was enough evidence to warrant compensatory damages and to what amount that would be. Overall, the Judge made a decision that the general public would predominantly agree with. Judge Richards condemned the actions of the police officers involved and provided an unbiased reflection. The compensatory damages are an expectation that is acceptable when any member of the public is treated unfairly and with such aggravation by sworn police officers who are employed to serve the community, preserve the peace and protect life and property, as per the Victoria Police Act 2013. The narrative behind the case of Cruz versus State of Victoria has been reported on by all major news outlets in Australia. The significant media outrage was a result of several factors: the extent and brutality of the Victoria police officers' actions, the large landmark sum of damages awarded to Mr. Cruz, the fact that it was yet another case of police brutality against a First Nations person in Australia. In recent developments, the Uruk Justice Commission 2023 held a hearing where they heard testimonies from Mr. Cruz and his family, who recounted the traumatic events of the raid and their frustration in how their complaints were handled. The IBAC investigation and their report found that complaints of excessive use of force should have been substantiated. While the Supreme Court found that Victoria police officers had corroborated their stories to paint themselves in a better light, and one officer had not acted truthfully at all, the Uruk Justice Council heard that despite the IBAC and Supreme Court findings, Victoria Police positions on their actions of their officers remain unchanged, and in the eyes of the organisation, the officers in question acted lawfully, causing particular outrage amongst First Nations communities and other professionals. The creation of the Disclosure Action Plan by the Victoria Police resulted in part from the Cruz versus State of Victoria case, and in response to the amount of publicity it gave to instances of police malpractice in Victoria. The Disclosure Action Plan involved a complete review and redraft of Victoria Police training at the fundamental level in order to place an importance on consistent and transparent disclosures. The decision to update Victoria Police training directly resulted from the judgments in Mr. Cruz's case. Cruz versus State of Victoria also appears as a case study in the review of Australian Federal Police powers, a submission to the Parliamentary Joint Committee on Intelligence and Security. In the case study, the Australian Human Rights Commission highlighted the unlawful arrest and how it was allowed to be carried out via extreme and misappropriated anti-terror laws under the Crimes Act 1914. In November of 2023, the Australian Government introduced the Counter-Terrorism and Other Legislation Amendment Act, which contained an amendment to the Crimes Act 1914, dealing the strict protocol for obtaining a post-entry warrant from an assessment officer and the information needed to ensure that the warrant is necessary, lawful, and that the power is not abused. Below are 3 examples in which times that Cruz versus State of Victoria has come to serve as a benchmark case for aggravated and exemplary damages for instances of police use of force and malpractice in the State of Victoria. As stated by Mr. Cruz's lawyers at Robertson Gill, the judgment in this case has been referred in 3 other court proceedings, with the main purpose of the reference being the decision to award aggravated and exemplary damages. Thank you.